So this panel will be moderated by Professor Filippo Zatti, who is at the confluence of law, business, economics, and technology, serving as a professor of economic law at the University of Florence. Well, there are a lot of Florence today. Professor Zatti has dedicated his career to the intricate landscapes of capital markets and banks and the worlds of distributed ledger technologies and artificial intelligence. He's the author of numerous publications in these fields. Professor Zatti is also the scientific coordinator of BABEL, which is a pioneering research unit on blockchains and artificial intelligence for business, economics, and law. Beyond the academic realm, his advocacy extends also to international platforms. Among other duties, Professor Filippo Zatti is a research associate at the UCL Center for Blockchain Technologies and a member of the academic advisory body of the International Association for Trusted Blockchain Applications. In his many activities, Professor Zatti is committed to shape the future of business, law, and economics in a digital world. So Filippo, I'd like to express my sincere thanks for having agreed to assume the delicate role to moderate this huge panel on DAOs in the EU. Thank you very much. The floor is yours.
What to say after this delightful presentation? Thank you so much, Florence. I'm very glad to be here. I sincerely think that there are not many universities in the world that while you are talking, you can see the lake from the windows. It's very beautiful. And also there is a great, I can say, probably the most distinguished scholar talking about decentralized autonomous organization. My commitment here today is chairing this panel, as Florence has said. The panel is about decentralized organization in the EU. We have many speakers that I'm going to introduce one by one. First of all, I want to make just a very, very short premise. This year, during the World Economic Forum in Davos, the Finnish Communications Ministry, Mr. Timo Harakka, said, break it. The European Union should consider legislation to, and I stress only this word, to me, as a public scholar originally, is particularly relevant, especially after Joshua named sovereignty. Consider legislation to recognize decentralized autonomous organizations that govern Web3 applications. Legal recognition to govern tokenomics or DAOs and decentralized finance together, even if partially non-fungible tokens, as all we know. So what could the European Union do or should do for the best recognition of this new legal concept? We will talk in the first part of the panel with Biyan Mienert. I invite Biyan to join us on the stage. Then we have distinguished scholars from the University of Lisbon and the Observatory of DAOs there, Madalena Perestrelo de Oliveira and António Garcia. Rolo. And after the break, due to 20 p.m., also with Anja von Rosenstiel, that you have already heard about. I'm sorry if I don't pronounce correctly your name, but Sabine van Haecke Lepic and Andrea later. To then open the discussion at 10 to 6 p.m. when we go into, after the discussion, going to close the first day of this very, very interesting conference. I can say also at this time, because all the speakers were of a high value, and we have to thank Florence as well to have organized this important international conference. Biyan Mienert, very young, instead of me, 1993, but was important, is a lawyer in the field of blockchain technology and is also lecturer for digitalization law at the University for Applied Science in Essen, okay? And especially conducts research and advises on the legal issues and structuring of decentralized autonomous organization as well, NFTs, Web3, and token offering. But what is relevant to me, she is, as I told before, because I met him outside, he wrote in 2016 and was and was published and is in open access.
Yeah, okay.
Your thesis, PhD thesis, is published in 2022. I don't pronounce it. You can do it if you want in German. In Germany is yes, decentralized autonomous organization and company law. But the subtitle is very interesting to me, and I leave you the floor to you after. On the tension between blockchain-based and legal rules. Thank you.
Thank you very much. Thank you, Alec. Thank you very much. I'm really happy to be here. Thank you for the applause. And thank you for the introduction. It's quite interesting that Alexis was here because back then in 2016, I heard his speech in Germany about the DAO, and it kind of was the trigger for me to write my PhD about DAOs back then and started back then. So it's really nice. I told him that I met him here again. And so today I'm going to talk about how to manage DAOs. So we heard a lot about legal wrappers and how to manage them, how to set them up, but I want to take a different approach than everyone here, and I'm of the opinion that if you launch a DAO, you should do it without a legal wrapper. And we heard a lot about decentralization, full decentralization. I want to kind of fill that open question, what does full decentralization mean? And so to go through that, that's the kind of how I want to go. The intro, I will keep it short. Also DeFi, most of you know what DeFi is and why DeFi is the main DAO use case. I will keep that short. But what is interesting, I want to look at the current legal structures and show and how I've practically done it now. I've been working crypto as an attorney and legal advisor for since 2016, 15, almost 7, 8 years now. How you can actually do that. And I want to give you also who are practicing law some advice how you can advise your clients, because if we start and look at the DeFi protocol evolution, we have always at the beginning decentralized code. And what is the big thing about decentralized code? It's running everywhere on different nodes, so there's no single point of failure. Out of this decentralized code, we develop smart contracts. I mean, we can have a full debate if they are legal contracts or not. I think they can be, but don't necessarily need to be. And out of the smart contracts, we have DAOs. So on a technical level, we don't have a single point of failure. But now we as a lawyer start, and I mean, I wrote my PhD about it, and I've done a lot of DAO structuring with legal wrappers, but we introduce a legal wrapper, which is then the single point of failure of that organization. So if we look at the traditional kind of DAO definition, which is autonomous, and for me, autonomous also includes that's autonomous from a state. Always, if we wrap the DAO in a full legal wrapper, then we have a state who could dissolve this DAO. And we saw that in all the DAO laws, that there's always the backdoor, that the state can shut it down. They need to have an upgradable code, and it goes against this core idea of a DAO, which should be autonomous, which should run on a decentralized protocol. And so I think for us as lawyers, it's also, and academics, it's also important to look at that side that we actually don't want to create that new single point of failure, what technology actually dissolved. So we can skip the point. I think everybody of you knows what the core principles of DeFi are. And I think we should keep that and have this idea and not have something which is fully decentralized, put in a centralized structure. So of course, DeFi is the main DAO use case. Basically, we have at this point, almost 40 billion total value locked, which dropped a lot because most of the total value locked are actually the governance tokens, which lost 80% of their value, most of them. And the biggest ones, we heard about it a lot, MakerDAO, Uniswap, and Aave. And I don't want to dive too deep into these, but want to look at the legal structure that they use. Especially MakerDAO, we heard that they dissolved a foundation, which I think was the right move. And I think, for example, from Uniswap, that they actually intervened and censored their front end for token actually was, I think, in the long run, a bad move from them because it shows that they have centralized control over their protocol, at least over the front end. So now if we look at the legal structures of DeFi DAOs, we heard a lot of different legal wrappers, most of them offshore, and I've also done a lot of the offshore structuring with the Cayman Foundation company, the BVI token issuer, maybe a Panama Foundation on top. Then I excluded the Swiss here because we already heard a lot about the different Swiss structure possibilities. Then the EU gives different possibilities, but I think all of them have this point that they, as I said, create the single point of failure. So I think the idea I have here now is to really start a DAO and go back to the core idea of a DAO, which is a fully decentralized autonomous organization without a centralized point of failure that we would have with that one legal entity. So now the big question is, how can you actually manage and legally advise this unincorporated DAOs? So I think the solution for that is the so-called co-deference idea, which means you use mainly on-chain agreements. Because if we look at most of the DAO litigation, a lot of it comes from the inside, people who lost money, who are DAO participants, who put their money into that, and how can you avoid that? So what I advise on is to have an on-chain participation agreement that everybody who votes signs that with their EOA, externally owned account. So in this participation agreement, basically, you lay out the legal rules that everybody in this organization, on this structure, kind of works with. So you have an indemnifier, everybody indemnifies itself, then we kind of can exclude that risk that comes from the inside. We include a binding arbitration. And also, we make the code as a rule, so everybody is bound by the code. So basically, if people want to participate in that DAO and accept the code as it is, they can't then sue the DAO as an unincorporated, as a general partnership and say the code was wrong because they actually agreed to it and signed this agreement to it. The other thing you can do is have a DAO charter where you kind of lay that out, and the goal is here to also make it really difficult for a potential plaintiff to claim that this is a general partnership. And that's the second risk which would come from the outside. And I think if we eliminate the biggest risk from the inside and then from the outside, if it's a fully decentralized entity, there will also be no point of enforcement against it. So that's where kind of the idea comes from. And if we look at this DAO cases, what is interesting, of course, there comes the big risk. Everybody's now scared about their personal liability. But up until now, we did not have any enforcement against a natural person in that. It was always somehow the founders. And I think the problem that we always came back down to was that these DAOs were not decentralized enough. So I think if you're just running a business, you should not just name it a DAO. You should just use a business, run it as a business. You can use decentralized structures, but this also puts away that pressure of being decentralized if you are not. Because we had a lot of different lawyers say their clients want to have a DAO, but they want to keep some power. So I advise, if we want to keep the power, it doesn't make sense for you to launch a DAO. Then it makes sense for you to use a business entity, to use the benefits of it and not put the pressure onto you to kind of be decentralized if you are not. And I think it was, as we also said, it was a lot used just for regulatory arbitration to use this DAO. But I think if you really are about that decentralization, it will really help. And why is it important? Also in the context of legislation that we are going to see. So the next point is MiCA. Everybody was, first of all, MiCA probably this excludes DeFi. And this is interesting, during that time I was working at BaFin and we were kind of in the council for MiCA. And the idea why everybody thinks that it's excluded is because of recital 12a in MiCA, which says if something is fully decentralized and has no intermediaries, it falls out of the scope of MiCA. But now, of course, the big problem is what does it mean? And everybody tackled that. I want to tackle that in the next slide. But first is, when I looked at that is, okay, what does it mean for DAOs and DeFi? So I looked on the backside to look at the crypto asset service provider definitions in MiCA, and I will come to the conclusion that most DAOs who have a legal wrapper, they will fall under the scope of MiCA, and they will need a license in the future. So I think for a lot of DAOs, having this legal wrapper can shoot them in the foot if they don't want to get a license and be a licensed entity who provides financial services within the EU. So the key here is to kind of fill that idea of full decentralization with life. And I think the first problem, of course, is that MiCA kind of mixes decentralization and disintermediation because they refer to both of it. But decentralization can be different also from disintermediation. And that created actually the regulatory uncertainty for DeFi, which will ultimately be interpreted by courts and NCAs who will kind of need to fill that life, what full decentralization means, and give some kind of legal framework to work with. But up until then, I want to share with you best practices for decentralization and for full decentralization that actually I used the whole time to kind of, and I get that a lot in the last years from clients that they ask, can you check our decentralization? Do you think, are we fully decentralized? Do we fall out of this regulation? And then we also can come back to the US law and the SEC. Basically, the SEC director for corporate finance in 2018 said, if the project is sufficiently decentralized, it can't be under an investment contract. So it's kind of more towards the security, but I think it's really comparable. And I talk with a lot of US lawyers, there's a lot of good papers on decentralization, and I think the core principles, of course, to decentralize your on-chain activities that we need. And this includes, of course, how you launch the token, have a community governed, don't have a VC who's owning 20% and can overturn every vote that you have on your protocol, and have an open source code. Everything needs to be open source and everything needs to be fully decentralized. You can't keep the control. But this is also the key. If you don't keep the control, you will also not be liable for it. So this goes hand in hand. And I always try to explain that to founders. If you're ready to hand it over to the community and fully, and not try to somehow lead the path, it also reduces your personal risk and the whole risk of your team in a very big and very safer structure that some of the legal wrappers do, because a lot of them don't really wrap the DAO. They just sit on the side because it's very hard, depending, you always would need to KYC everyone who needs to be part of it and so on and so forth. And we saw that with all the problems that we talked about, the DAO laws, it's always very hard if you have anonymous persons participating in that DAO to actually have them wrapped and have them legally protected. So I think the only way, if you have a true DAO with anonymous participants, is to be fully decentralized, or you won't have any liability protection. That's the only way. And so the second key is there to also decentralize off-chain activities. And I think that's the biggest issue. The core team needs to move out and say, we are not the core team anymore, we are the initial contributors. And then you need to decentralize marketing, business development, product development, partnerships, and of course this gets really hard. But I think the key here is to kind of build sub-DAOs and involve the community, and that the community can also work on the roadmap, work on partnership, propose partnerships that they are worked on, and help developing this structure. Of course, and they're coming to the next point, there's this problem with efficiency. A centralized structure is always more efficient than a decentralized structure. And so that comes back to the first question. If you want to run an efficient for-profit business, the DAOs may be not the thing to do for you, but if you want to run a decentralized structure, a protocol which is open for everyone and want everyone to participate and build that up, then the DAO is maybe an idea for you. And so this off-chain activities, it also goes back to that, and then we come to US securities law, that the core team doesn't have this information asymmetry anymore. So you can't keep things private anymore. Everything needs to be transparent and public, because if we go to the how definition, it's always if you have managerial efforts, what investors could expect the team to do. So this goes back for the teams that they shouldn't engage with exchanges to list their token. They shouldn't try to pay money for partnerships that creates value. This should come naturally, and this should come out of the community if you really want to run this decentralized structure. And I think this can basically, for the US and also for MiCA, then if you fulfill these decentralized parts, this can really help to fall out of that regulation, because if you are fully decentralized, there's no way that you can basically fulfill the obligations of a license regime. But if you are centralized, you need to be ready also to face that license regime that we will see in the EU and that will probably come in the US. And I think MiCA kind of puts the pressure now on the projects to either be centralized and get a license, and then you can passport it like with the MiFID II directive and can run your business. But if you want to be decentralized, then you actually need to fulfill these points. And I think that's leading to my almost final slide. It creates that idea that MiCA does not exclude DeFi. Like real DeFi may be excluded by MiCA, but I think at the end, MiCA creates also a lot of legal risks for DAOs who are not fully decentralized, for all these projects who kind of use the DAO just for regulatory arbitrage because they didn't want to fulfill license regimes, or they didn't want to, as we have heard before a lot, they didn't want to kind of fulfill legal requirements. And I think these centralized DeFi structures, they will develop towards a license regime like we see now from big lending protocols. Like, are they building up DeFi for institutions where people will need KYC? Institutions don't want to be in liquidity pools where they might be tainted coins. So we will see develop that, but this is more a kind of more decentralized version of CeFi, but not real DeFi. But I also think for most of us as lawyers, academics, we also need to rethink our approach, how we give legal advice. I think we need to rethink if we want to put everything in structures that we already know, that we think, oh, a client comes, oh yeah, you should create an LLC, you should create an association. We should go more towards, if we have decentralized projects and clients who really want to be decentralized, to help them strategically how to decentralize. Because I think this whole billable hours, and I sell my template 100 times to 10 different clients, this will be broken if we see generative AI disrupting and providing legal documents in a very fast way, which will get better and better. We need to move towards that we give this strategic advice that how can you really decentralize? What are the legal pain points? What are the enforcement points that you are still fulfilling? And I think this is kind of the path forward in this decentralized finance if we really want to keep it decentralized finance. And coming back, a lot of questions might be, okay, but what if we need some real-world activities? What do we do with the IP? So first would be to kind of open source everything. On the other hand, I think would be possible to create kind of entities who are affiliated with the DAO, but who do not try to wrap the DAO, but who actually try. One entity could hold the protocol-based value and pay the taxes. One entity could hold the IP and always have a contract or be in their statutes to be enforceable that they are bind by the decisions of the DAO, but we don't need to try to wrap the whole DAO, just use one legal entity, and as I said in the beginning, create this one legal point of failure that we didn't have before and that this technology kind of tried to dissolve, and I think we shouldn't create that from a new. Although I also created a lot of these legal wrappers, of course, if your client asks for it, you kind of have to do it, and it's maybe better than just having a traditional centralized finance thing. And with my final slide, I kind of want to go back to the traditional idea of Thomas Hobbes' Leviathan, how states are managed. And to rethink that, I kind of badly photoshopped the sword away, which was in the hand, and which stands for that states and organizations are controlled with power. And here I think the basis, the blockchain, and the people are not controlled with power and punishment anymore, but with incentives. And if we go more towards that idea that we want to run an organization based on incentivizing and really incentivizing people, and not saying you get 5 tokens because you're doing our marketing, not but real, like distribute the value that might be in that DAO, we can create legal structures that work differently, or not legal structure, organizational structures that work differently based on incentivization and not on punishment. Thank you very much. I'm open for any questions, and if anyone's open, connect.
You stay on the stage.
I
And
think.
you wait for. You can wait on the stage if you want.
Oh, better. I can't.
Oh, better. Sorry. Okay. Next, we saved 2 minutes. We are going well. Because we are late, we are running out of time. So now we consider the Portuguese side, and I invite Madalena and António to join me on the stage. Madalena is assistant professor at the University of Lisbon, School of Law, where she has been teaching since 2011. Okay. Also, we have a PhD thesis, so in this case, but it's about investor protection, capital markets, and namely on civil liability for securities fraud and on the listing situations. Please, have a seat. Oh, this side. Yes, please. Okay, doesn't matter. You wait for. And you are obviously a speaker in many conferences. You come from the Center for Research in Private Law in the areas of corporate governance. And I think you are the head of the DAO Observatory at the School of Lisbon. Also, very interesting for us, Deputy Director of the Journal of Financial Law and Capital Markets. Okay? About António, and António is assistant at the, okay, sorry, António, just a moment. I have to catch your information. He's currently a guest academic assistant in the Faculty of Law as well, providing assistance in courses on securities law, corporate financial law, and so on. But you are in the past assistant at the Central Bank of Portugal, okay? I'm still working, sorry, okay. I wanted to be sure not to say anything wrong. And also is part of the Lisbon DAO Observatory. Just to, before leaving the floor, sorry, to all of you, just a thought about what Biyan said. There are a few economists talking about tokenomics. Which are the rules of the tokenomics? Which are the economic theory we apply to tokenomics? It could be helpful for legal scholar, for us as legal scholar, because the problem is to understand if we have to imagine new legal categories or have to manage to apply the old ones. I think this is the problem that we have to face. And I encourage economists to study. The first were the Australians, as I know, Jason Potts and the other, with the book. It was published in 2020. So I think it's important if you want to solve all these problems that the legal aspect make emerge. I leave you the floor. You have 30 minutes because you are 2. Thank you.
So, good afternoon, everyone. I just wanted to thank Professor Florence, Guillaume, and Sven Rive for this very, very kind invitation to be here today. I think that next year you should also host a DAO conference, but that lasts for at least 5 days so that we can enjoy Neuchâtel. That's absolutely lovely. It is a true pleasure to be here, and it's really an honor to be here with so many people interested in DAOs, so many specialists. And, well, after this very quick thank you, I'll give the floor to António, and then I'll pick up.
Good afternoon, everyone. Presentations were already kindly made by Filippo, which I thank you very much. Of course, as Madalena did, I want to thank Professor Florence, the LexTech Institute, and the University of Neuchâtel for the privilege of being here and being able to, both me and Madalena represent the Lisbon DAO Observatory. We've been working on DAOs in the past 2 years. It's been quite a ride, honestly, and still going, and hopefully going for several more years. So it's an honor to bring also our project here. No need for further presentations on ourselves. Just a small remark on our project for those who don't know us. The Lisbon DAO Observatory is a research project co-founded by me and Madalena as co-principal investigators, and it has the objective of trying to find legal answers to the current legal challenges posed by DAOs and similar arrangements in order to help further shaping further legislative action, if any. So the achievement of this objective has been made possible by several consecutive steps. We had a first DAO legal structure workshop in Lisbon last year, where we gathered representatives from the industry for them to share with us how, what? Sorry. How they, are you okay? Okay. How they feel about the legal challenges they face, how are they structured, how is their membership. It was a really enriching experience. It was our first contact with the DAO world, with people from the industry and from the ecosystem. So it was a truly enriching experience. Thereafter, on May 2022, we organized a follow-up event in which we gathered scholars from all jurisdictions, from a lot of jurisdictions in Europe, Portugal, Germany, France, England, where they would say how DAOs would be treated under their law, and then representatives from more forward-thinking jurisdictions, Wyoming, Vermont, the Marshall Islands, which at the time already had specific tailor-made regimes for DAOs. It was also a very interesting experience just to get to the cusp of how the status quo is formed. And finally, in the meantime, we organized a DAO hackathon. It was really fun, a great challenge, but really fun, last November in Lisbon. And lastly, Professor Florence honored her with her presence there. We had, in April this year, a conference on DAO regulation just to address the major topics of any future regulation, if any. But enough about us. Just don't forget, visit us at our website, like and subscribe on LinkedIn. We don't have any other social media, but so like and subscribe on LinkedIn. So, first of all, just a small reference, of course, as Professor Florence has addressed in her intervention. Of course, there are several concepts of DAOs. It's far from being a closed concept, and they are difficult to define with precision. And we have very wide concepts, such as the initial one proposed by Vitalik Buterin back in 2013 or 2014. We have some other concepts which are more narrow and more associated with the organization aspect of DAOs. But at least our starting point for our presentation the definition is not that different from the definitions Professor Florence has proposed, so which is a good thing, I guess. So basically, we would say DAOs are forms of human organization based on blockchain technology in which various members pool funds or assets, which can be of any nature, namely crypto assets, but not necessarily, to undertake a given activity, whether for profit or not. They're partially governed by, or mostly governed by, a bundle of smart contracts deployed on a given blockchain. And as the name indicates, they are simultaneously decentralized because most DAOs seek to have no centralized management, instead placing important decisions in the hands of the associates, seeking to mitigate the traditional agency problem between shareholders and management in traditional companies, and autonomous because many decision-making powers traditionally held by management can be entrusted to a smart contract that defines the rules of the organization and usually holds the DAO's treasury and manages voting. Membership structures, of course, vary wildly, with different DAOs having different forms of attributing membership. Usually, members have some kind of governance token that gives them political rights and, of course, some patrimonial rights as well, economic rights, and exit mechanisms. Those vary also widely among DAOs. But let's then move on to having this defined, let's move on how DAOs would be treated under Portuguese law. And in this part of the intervention, you'll notice that some of the issues have been already repeated from past interventions. That's not a glitch, that's on purpose. That's on purpose, no, that's natural, because it shows that the reaction, which is not an intentional reaction actually, but the reaction of many jurisdictions is quite similar, so it's kind of poetry, it rhymes. So basically, DAOs, as in many other jurisdictions which do not explicitly recognize DAOs, they have no recognition in Portuguese law, and like, for instance, those special jurisdictions with explicit recognition, such as Vermont, Wyoming, and most recently Tennessee or Utah, or those who implicitly might acknowledge DAOs. Sometimes Malta is cited as an example, but that's another story. So basically, with no explicit legal recognition, if a Portuguese judge were to deal with a situation with a DAO, let's imagine a pretty streamlined model of DAO with token holders, with no special governance rights, so no different categories of governance rights. So those token holders would decide on major issues, smart contracts automating other aspects of governance and undertaking, for this situation to be easy, let's imagine a for-profit activity, like let's say DeFi, who knows. So before this kind of streamlined version of DAO, how would a Portuguese judge approach this? Well, a judge would look at DAOs from two possible perspectives, but the main one would be to apply, as there is in Portuguese law, as there is in French or German or English law, they would apply the civil law partnership regime. So Article 980 and the following articles of the Portuguese Civil Code, which deal with those civil partnerships we call sociedades civis, which would be the equivalent to société civile in French or the Gesellschaft bürgerlichen Rechts in German. So a civil partnership will exist if two or more, according to Portuguese law, if two or more people undertake to pool assets or services towards jointly undertaking an activity and agree to distribute, in some ways, the proceeds originating from that activity. The definition is very wide on purpose because the idea is to catch the most situations possible. So the idea is to be wide and not restrictive. It basically catches most forms of collective human economic activity. In order for a judge to identify a civil law partnership, it requires the presence of a personal element, so people, okay? Members who can exercise varying degrees of control and whose money is on the organization. A teleological element, so carrying out an activity which can be more or less profit-oriented, but not required to be profit-oriented. And then a material economic element, so pooled resources and splitting of eventual proceeds or gains. This qualification, this is very important, and it mirrors and I think it's more or less the same everywhere. I know that in common law jurisdictions it is like this. This qualification applies regardless of the will of the participants to specifically create a civil law partnership. So even if you don't want to, if these requirements are met and if the judge cannot subsume this to any other situation, it's a civil law partnership whether you want it or not. And what are then the consequences? Once again, echoing other presentations. Of course, civil law partnerships under Portuguese law have no legal personality unless specifically requested. So usually they are informal, but if you want, it's not very common, but if you want, you can register the civil law partnership and it will become a legal person. But usually they don't have legal personality because we don't use civil law partnerships a lot. I personally know of no case, so it's not even used for like less profit-oriented purposes, as sometimes it is in Germany. So most people who end up being on civil law partnerships are there because they didn't want to be there, didn't want that regime to apply. Unless it has agreed otherwise, so this is the second consequence, unless it has been agreed otherwise, all members of the DAO will have by law equal governance power to govern the partnership directly and without management. All members of the civil law partnership, sorry, not the DAO, I'm getting ahead of myself. Then, and most importantly, all members will be personally, unlimitedly, and jointly liable for the partnership's obligations. Because there is no legal person to speak of, any creditors can bring lawsuits directly against the members, if they can find them, of course, but that's another story. But they can bring the lawsuits directly towards the members. And now a specificity of Portuguese law, which, as far as I know, it's not very common in other European jurisdictions. This joint and unlimited liability, it's tempered by a rule which requires creditors who file a lawsuit against a civil law partnership to first recover any amounts from corporate assets, so the collective assets of the partnership, and only then go after the members/partners. Of course, that the liability would still be unlimited because they can go after any amount in regards to a certain partner. So it's not limited to the quantity of money or assets it has pooled. So it's not exactly limited liability. Traditionally, one can use the Latin expression beneficio executionem. So it's you have to first take out the money, the collective money, and then only subsidiarily go after the partners. In a more problematic rule for DAOs, partners will, in civil law partnerships, will also only be allowed to transfer their shares with the consent of the remaining partners. So that's, of course, civil partnership law is thought of for like smaller and more informal arrangements, but it's also an applicable rule. And of course, as I mentioned, these consequences are, of course, not limited to Portugal, as we know. Both in civil and common law, most DAOs would be, as many of us have emphasized, considered partnerships or civil societies in civil law jurisdictions. As long as there is that permanent structure that makes membership meaningful, as long as there is a joint purpose, as long as there is member control, as long as there is some kind of distribution, it doesn't have to be profit distribution, but some kind of economic distribution among members. That is the case, at least from my direct knowledge, at least in French law, as Florence has already mentioned, so the Société Créée de Fait. As far as I know, in German law, they would be considered either civil companies or GBRs or open commercial companies, OHGs. And in English law, in most US states, will be considered unregistered partnerships. And in many of these jurisdictions, and Portugal is one of these cases, they will be more conceived of as a contract than exactly a body or a corporate entity. As in Portugal, as in most jurisdictions, judges will emphasize the usefulness of a wide, non-strict definition of partnership. The idea is to include more than to exclude. But of course, the consequence of being classified as a partnership is also more or less the same everywhere, as we have seen. No legal personality and unlimited and joint and several liability, which is not fun and not, of course, not adequate for DAOs. And it's interesting to think that even though DAOs are this very recent phenomena enhanced by the potential of the blockchain, it's very interesting to see how, in a way, they have took us back to a time because, well, companies, as most of us know, are fairly new phenomena in the, well, at least in written human history. So companies with legal personality and limited liability available to everyone are probably like for the last 150 years, 200 years, depending on the place. So before, people used to have more informal partnerships in which they could do business collectively. So it's interesting to see how DAOs bring us back to basics in a way by eliminating the specialization that is associated with companies and the specialization that leads to specialized management and the separation between ownership and management, which is very interesting to think of. And even a lot of speakers today mentioned the difficulty in finding jurisdictions for DAOs. And it's interesting to see that there was also a time, at least before nation states were formed, where also jurisdictions were difficult to define because, okay, there would be kingdoms, there would be duchies, there would be whatever, but it wasn't as straight as today with nation states. And it's interesting to think that maybe some solutions from the past can also be recovered. In any case, of course, the status quo of DAOs being partnerships is untenable and unsustainable, and the legal uncertainty is clearly not helping, as it subjects DAOs to a framework that was thought of for small, informal arrangements with usually small number of people. So the application of the partnership framework to DAOs, as it would be in many countries, is an interim solution at best, but these frameworks are, of course, very unsuitable. Partnership law is certainly not tailored to the needs of a fairly big organization with potentially thousands and thousands of members dispersed all over the globe and managing funds of immense value. Therefore, one needs to start thinking about DAO regulation, and one must answer to several questions and address key issues. That's what we're also doing at the Lisbon DAO Observatory. First of all, the great question, should DAOs even be regulated? We saw different answers today. So one must bear in mind that states or international organizations can simply not regulate DAOs and leave like kind of this Wild West thing still going. It's possible to do so. Should that regulation be imposed by the state or by international organizations, or should it be self-regulation? We've heard a bit about self-regulation as well. Should it be holistic? So should it be like the state creates an act just for DAOs and with all aspects of DAO life inside that act, or does it fine-tune existing laws to address DAOs? Who knows? There are a lot of possibilities. But we should keep in mind when thinking about regulation which is a great challenge nowadays to think about what any future regulation of DAOs would look like. We should keep in mind that DAOs, like many phenomena that emerge from the blockchain, have a strong ideological undertone that has been also and already stressed here by a lot of speakers, almost like kind of anarcho-capitalist in nature or libertarian. And so a lot of underlying a lot of DAOs, there's these ideas of constructing communities or relationships parallel or immune to state-created law, which many more ideologically driven users seek to escape. However, one could also argue that without the acknowledgement of the subjection of DAOs to the general law, be it in a tailor-made regulation or not, many outsiders from the blockchain and the Web3 world will be weary of jumping in on the potential and the great potential that blockchain in general, and DAOs in particular, provide. So normal people, let's say, people who are not into the space, will be driven away by fear and by legal uncertainty. And keeping DAOs underground will probably do not a great work of making them mainstream, if that's your objective. If not, it's fine. Therefore, any regulation of DAOs, as it happens with most phenomena in the blockchain and the Web3 universe, must be mindful of striking the right balance between alienation and legitimation. On one hand, not blindly applying the same principle existing in state legislation and risking alienating the more hardcore or ideologically driven users, which were at the origin of the technology, are the main drivers of innovation, so the state must not alienate them, and who would, if the state did, they would continue to use the technology and escape the state nevertheless. On the other hand, one must create balanced frameworks that create a more inviting environment for other people to jump into this wagon. This works as a legitimation, and I say legitimation in the true etymological sense of the word. So legitimation comes from Latin lege, which means law. So it's to create something, to provide law to something, actually. So this legitimation, in the very literal sense of the word, can make, of course, this not only applies to DAOs, but to other blockchain phenomena, much more attracting. Let's see in a couple of years if Mika, for instance, did the same for crypto assets in general. Let's see. In any case, the idea that DAOs can simply escape the law, with all due respect, is naive at best, I would say. Because theoretically, nothing escapes the law. Of course, materially, people can escape the law. There are criminals and parallel states and rogue states and whatever, but theoretically, no. So if a situation involving a DAO comes before a judge will try to qualify it and solve the issue with whatever data it has, whatever materials it has at its disposal. Is it better to leave judges to qualify DAOs as civil law partnerships which are not made or compatible with the principles and the objectives of DAOs? Or maybe give them tailor-made regulation? Maybe the latter, of course. It will not be easy, as Madalena will explain now. Many issues have still to be addressed. Once again, state regulation, self-regulation, what degree of decentralization, mandatory governance or not, how to protect creditors, how to enforce criminal law, and so on and so on. So millions of aspects to address. But this regulation, in any case, will have to be balanced as to foster the growth of DAOs in a safe environment. Though I would say, at least for me personally, that the growth of DAOs or the domination of DAOs is an objective per se, I do think that creating a tailor-made regime for DAOs is all about giving flexibility for people to experiment with different governance models outside the traditional centralized models. Okay, we have these centralized typical models already at the disposal of companies. Why not let people experiment with different governance models, something that the blockchain facilitates, something that DAOs provide and enhance? So it's kind of a kind of laboratories of governance in a way, in the sense that if we leave through balanced regulation with balanced minimum requirements, if we leave enough space for different DAOs and different groups of people to experiment with different regulation, the results could be, well, we cannot even fathom what the results will be, but probably good results in terms of governance and finding governance models. So let's make DAOs these laboratories of governance through balanced regulation, which establishes the bare minimum at least, but gives space for of course, more experimentation. And now I will pass the word to Madalena, and thank you so much for your attention.
So in terms of philosophy, DAOs represent freedom, but this freedom comes with legal consequences, as we have discussed the whole day regarding liability, being it liability for the DAO's debts, being it civil liability, criminal liability, tax liability, and so on. However, it should be possible to have freedom and legal certainty and legal protection at the same time. So I believe it is our role as professors, as academics, as legal practitioners, as industry members, to push forward to find the best legal framework for DAOs. But I also believe that it is our duty to think outside the box, not to try to say that DAOs fit into categories and legal figures that we already know. So we need to think outside the box. We need to build new solutions for DAOs that fit this new reality, because DAOs are fundamentally different from corporate structures. So when we think about legal framework for DAOs, I believe we can make an analogy with pointillism. So pointillism, as you all know, is a technique of expressionist art where a painting is made of many individual dots. And the viewer can only grasp the whole picture when he takes a step back. And that is exactly what we need to do when assessing the legal framework for DAOs. We need to take that step back and think of the whole legal system, starting with private law. So private law lays the foundations of our legal system. Private law is flexible by nature because it is designed as a framework for freedom. Freedom of contract, freedom to interact, freedom to set up new solutions. And so, as Canary states, the legal system is an axiological or teleological order of general principles that ensures consistency, coherence, and inner unity. But these are very crucial points. The thing is that coherence and inner unity does not imply an approach based on same business, same risks, same regulation. On the contrary, same risks may entail different regulations if the whole ecosystem where they are presenting themselves is completely different. So a better approach would be, as Sven already touched upon today, the one followed in Koala model law for DAOs, which adopts the idea of functional equivalence. So functional equivalence allows for the establishment of an equivalence between an object already within the scope of a legal rule and another object that is not yet encompassed by it. So the idea and the example Sven also brought us today is that, well, we have paper-based documents and we have electronic documents. There is a functional equivalence that we can make between the two of them. When we take this to regulation, we can speak about regulatory functional equivalence, meaning that we need to assess the specific objectives of a given regulation and assess if they are being achieved via a different way, namely a technological means. So, for example, regarding DAOs and legal liability and legal personality and limited liability, we should ask, why does it, in general terms, limitation of liability and legal personality usually require corporate registration? If we open any corporate law book, we will read that corporate registration brings publicity, brings certainty. But, well, these values of publicity and certainty can also be achieved via different ways. So this is the idea behind the Koala model law, that if you deploy a DAO on a permissionless blockchain, that objective of publicity and certainty is achieved by the blockchain. Another example is decentralized finance and disclosure obligations that are imposed by financial law. So we know that most governance tokens are usually qualified as securities. It is said that they fulfill the requirements of MiFID II. There is transferability, tradability, homogeneity, but I highly doubt that they can be functionally comparable to traditional securities. And why is that? Because the relationship between a token holder and its issuer, being it a DAO or any other entity, is fundamentally different from the relationship between a shareholder and an issuing company. This is why, this is because a token is only a cryptographic key that by itself does not grant any rights to its holders. The tokens grant the exact rights that result from the contractual nature of the relationship between the token holder and the DAO. And so the expectations that the token holder holds vis-à-vis its issuer, vis-à-vis the DAO, are completely different from the expectations arising from a shareholder relationship. So this means that the need for investor protection is also different. So we know that the cornerstone of financial regulation is disclosure. It is said that disclosure obligations exist to preserve market integrity, to ensure that, and by that way we protect investors. But when we look at a truly decentralized ecosystem, it shouldn't be, if it's truly decentralized, of course, it shouldn't be, there isn't any information asymmetry. Biyan also said that in his presentation. So what sense does it make to apply financial regulation, being its prospectus obligation, the obligation to publish a prospectus, to disclose ongoing information, periodic information, and so on, if there is no asymmetry of information in that specific ecosystem? So this is the idea behind functional regulatory equivalence. Well, of course you could ask, well, but do you really want tokens to be traded without information? Of course not. The point is precisely that all relevant information, if we are looking at a fully decentralized ecosystem, is available on the market. Of course, you could tell me, oh, but the information is available in a completely unorganized way and not standardized way and so on, and then we should regulate the way the information is being made public. But the thing is, when it comes to regulation, we should also consider proportionality. So is it really proportional to impose disclosure obligations only to ensure standardization? Of course, standardization comes with, makes information easier to process and to understand. That's true. It has also been said today that most token holders do not understand information available on the internet. We saw the cat meme and so on. But the thing is, in financial markets, most shareholders do not know the information that's available to the market. The idea behind disclosure obligations is, in general terms, the efficient market hypothesis. And the efficient market hypothesis says that, that asset prices reflect all public information that is available at a given time. But it does not say that every investor on the market knows the available information. It says, well, we have professional investors, and those professional investors know the information, and then we have retail investors that mostly go with the flow, go with the market. So I'm not preoccupied with an ecosystem where information is not provided in a standardized way, as long as the information is there, can be used by everyone who wants to. So I believe that when regulating and deregulating these arrangements, we should not focus on the traditional types of disclosure that we all know, prospectus, ad hoc information, and so on. We should focus on, this is, okay, I'll just a bit more, okay? Yeah, absolutely. We should focus on disclosing algo governance, the governance of algorithms. We should focus on ensuring that the algorithms are robust, that the community knows who holds the administration keys, that the community knows that even if you have a protocol based on a multi-sig protection, that is possible that only one person can concentrate the whole, the powers in just one hand. So I also want to address the idea that DAOs do not escape the law today. So, of course, we know there are partnerships under most EU jurisdictions. we know that in most jurisdictions, the governance tokens are qualified as securities and so on. And I'll also agree with what Biyan said, that MiCA can apply to most existing DAOs today. Because, well, Recital 22 says that where crypto asset services are provided in a fully decentralized manner without any intermediary, they should not fall within the scope of this regulation. But as we all know, true decentralization is a myth. So this joke has been made today many, many times. Oh, okay, this is not this slide. But it is said that DAOs are mostly just dinos, so decentralized in name only. We know that decentralization it's not a legal concept. Do I have like a few minutes more? It is not a legal concept. Okay, I'll keep talking. It is not a legal concept, and so it is hard, because it is not fair, I think.
50 minutes.
Okay, so I'll wrap it up.
Because, yes,
okay, I'll wrap it up.
Okay.
So true decentralization is hard to assess. Political decentralization involves also looking at off-chain activities. This means business development, IP, protocol development, and so on. We need to address that political decentralization. We need to assess whether there are crypto whales and so on. So it is possible to find so many points of centralization that could render MiCA applicable. But that does not mean that MiCA is suited for these kinds of arrangements. So we need to think about the future in regulation. What are the entry points for regulation? And I'll leave that for the debate. Thank you.
Thank you. And then we have the turn of Anja von Rosenstiel. We have already known about her. I want only to add, she's co-editing a European mediation journal and serving as a professional for Chamber of Commerce yearly mediation competition, if I am right. So, Anja is going to talk about the German side about DAOs. I leave you the floor. Obviously, 20 minutes, Anja.
Yeah, no, I will. Hi everyone. So everyone wants to go home. It's sunny. Now it's up to our last group to do something. And I was so fired up by your talk that I'm kind of hesitant to do my PowerPoint karaoke here and go a little bit off script in between. So what I actually would like to do is kind of give you the German context, because you know me more out of the American context now, but then kind of take a chance to...
Anja, can you take the mic?
Yeah.
There is a problem with the streaming.
Take a chance to take more of what I have heard all day long and kind of build that in, and the freedom, right? But to give you some of the context first, to talk about legal wrappers or the legal form for DAOs under German law, I wanted to give you, does it?
Is there any problem? Can I help you?
It doesn't really move
Yes.
on. Well, anyway.
No, they're going to change.
Okay.
I don't know why. I can try if you...
Yeah, but my 20 minutes.
Oh, yeah, absolutely. I stop.
Yeah, no. So the German context, I have two Germans, I think, sitting here. And we have had this big honor to have the initiator, or one of the initiators of the original DAO in this room this morning, and he said it was not a failure. And let's say if I take the academic perspective on German, the German discussion or discourse about how to legally wrap DAOs, usually articles start with the DAO, with the first DAO as a starting point, which, of course, frames the discussion in a certain way. It frames the discussion in the way that you already start with a legally wrapped DAO, and we have heard a lot about the entity-less DAO today, about the fully decentralized DAO today, about
And this kind of framing kind of skips the step of also we have heard about the ideal DAO, and kind of skips this first step. And on the other hand, it is, as we heard, an investment pool, an investment DAO, so it serves a specific purpose. So it kind of leaves out the discussion of all the other purposes DAO could serve, and frames it and has a very narrow scope or narrows the scope of the discussion very much. And so what comes out of it are definitions like this one, a permanent organization receiving its own capital. Permanent, we have heard that actually, who was it? MakerDAO actually closed down their foundation again. We have heard that the DAO had a hard fork, so there's much more dynamic involved with DAOs. It's not necessarily permanent, and it's not always about assigning capital or treasury to a DAO. So I find the discussion, I try to be also critical, like Jeff has been rather critical with the US situation. I try to do the same. That I see that as a little bit of a problem, and Germans usually start their sentences with "the problem is." So that is the situation I find when I look at the discourse, the academic discourse about German DAOs. And if I move on to the German regulator, I don't know if you have heard, there was a conference the German regulator organizes every year, and the press statement actually read that there should not be any blind spots in the flight radar. So basically a warning that entity-less DAOs or complete decentralization will not be tolerated by the regulator. And basically, we have heard it today by Biyan, that this kind of corresponds to jurisdictional arbitrage. This, of course, implies that there is kind of a deliberate escape from the law. But as we also have heard today, this is not always the case. Just in this coffee break, we discussed it, that sometimes there is not even an awareness of the liability that is involved. But this is a clear statement by the regulator that entity-less DAOs are kind of stepping into a danger zone, and there is actually regulatory enforcement action against Uniswap right now pending. It is, of course, not publicly shared, but there is something going on. And so there's also guidance by the BaFin on DAOs from a regulatory point of view. And basically, I give you here the definition. It really emphasizes the A in the DAO. So the decision of holders of governance tokens executed via smart contract no longer modifiable by individual actors. So it's a strong emphasis on the automation, and generally a statement in this guidance saying that there's a lot of fake DAO, complaining about the lack of transparency. We have discussed that today too, that also in terms of liability, involuntary creditors and so on, there needs to be perhaps a disclosure regime. So lack of transparency and also lack of automation. So that is the German regulator's perspective. And this kind of also looks like a challenging landscape for German DAOs to actually operate in. But I also want to give some light in the tunnel, perhaps in a certain way, that there has been some reform of German partnership law and light in the tunnel, and so far that if this is perhaps a first step, there could be a second step or a third step, that this kind of 120-year-old kind of put in stone civil partnership, which my friends also have discussed in detail from a Portuguese perspective, that there is some movement, there is some dynamic in there. This is kind of my takeaway, but for the time being, it actually makes it more difficult to basically just rely on this default situation. So we legal academics, and I take you up like freedom and let's do something. So we actually cannot just say, go through all these different legal forms and say they all don't fit, but there is the partnership model. Let's just apply the partnership model, because this reform actually introduces more formalities in German partnership law. So there will be in the future a registered and an unregistered civil law partnership. This means that some of the privileges are actually reserved for a registered partnership. And let's say that especially the legal capacity, so there's a differentiation in German law between legal entity and legal capacity. So legal capacity meaning the capacity to contract, to actually be sued or to sue. These kind of rights or capacity, as I said, so they are actually reserved for the registered partnership. And on the other hand, the German partnership, and the registration, as we all know, is of course an issue or a challenge for DAOs, because you basically have to reveal your members or your partners. But the interesting thing about this law in terms of lawmaking is that actually with registration, the German legislator combines certain positive incentives. So it's not kind of like a punishment or just let's say a precautionary measure to, for example, you mentioned publicity, to actually introduce some transparency for creditors, but actually you have certain privileges. And I skipped this. Interesting is in terms of conflict of laws. So if you actually are a foreign DAO and you want to come into Germany to actually have your real seat or your main business activity in Germany, you right now, if you're a non-EU company or a non-US company, you will not receive any recognition by German courts. It's the so-called seat theory. This means that you have to actually jump through all the loops again. And we have had this example of the DAO this morning. Actually, these were two LLCs, a German one and a Swiss one. We got the real reason. But actually, the Swiss LLC would not be recognized under German law due to this seat theory, because it would be unregistered, and so German jurisdiction would apply, and it would be unregistered and would not fulfill the formal requirements under German law. This is different under EU law because it's basically against the freedom of movement and the freedom of capital. So there's the so-called incorporation theory that actually is applied, which means that the seat of formation is the seat that determines the jurisdiction. But in this case, Switzerland not being part of the EU, this is not applicable. So this is the reform. But the takeaway for me really is that we cannot just rely on this default situation and fall back on this default situation. We have to think about something, because the civil law partnership becomes the kind of small commercial partnership, more formalized, the introduction of registration. So we cannot just fall back on that. And then there is the, which is also, no, I'm going the wrong way. No, this way. Sorry. The new, is it this one? No, this one. No, this one. Sorry. The new Electronic Securities Act, and I think that's a very interesting piece of legislation, because now kind of going off script already with all these legal forms, we all know, I mean, they're not so different in all jurisdictions. We all know partnerships, we all know limited liability companies, but we all also know that there's always one piece missing in each legal form. No legal form is actually a perfect fit. And probably one of the outcomes of this conference probably is that we might have to discuss a new legal form and how should we go about it. So with this new Electronic Securities Act, which is actually interesting, is that it actually applies not an entity-based approach, but a principle based approach. What do I mean? So the whole discussion about DAOs is very much focused on the O, on the organization. And if I talk about the ideal, the entity-less DAO, a lot of people doing DAO, it is more the organizing. It's not so much the organization, but the organizing and basically the fluid nature of the DAO. There is this huge challenge of the entity and everything that it implies. And this new Electronic Securities Act actually does not waste a lot of time establishing which entity would actually have to manage this register for electronic securities, but establish certain principles. And I think that could be a way forward. We have already touched upon it in several talks today. It could be a way forward how to discuss new legal forms, that before we all talk about one legal form, that we talk about principles. And you mentioned that with same risks, same rules, that we talk about principles that would need to be met. And here it is, you can have a register either centralized or decentralized, but it has to serve the principle of confidentiality, integrity, and authenticity. And one could think the same way for legal forms. We have discussed transparency, for example. How can you meet the principle of transparency if you want to form a DAO? And you have mentioned the publicity of a registry, which is the same in German law, the Publizitätsprinzip. So how then apply the technology? How could you actually replace registration, for example, with a disclosure duty, right? What do you need to disclose? But then with the advantage that you perhaps do not have to reveal the membership or other registration requirements which are hard to fulfill if you come in as a DAO. So to that regard, I find this new law quite interesting as a motivation or as an inspiration for our discussion. And also, we have talked about the different challenges to wrap DAOs today. I don't have to go into any more details. We have basically named them all. Also the advantages, Sven, you went in all the details. Most of all, limitation of liability, legal personhood, legal capacity to contract, non-profit purpose. But what I try to do is basically take these challenges DAOs pose for the existing legal forms and put them kind of in an order and took the advantages. Don't worry, I will not go into all of this. Now it's kind of the engineering approach to law, kind of like how to put together an IKEA bed, I guess. But I want to say something about the partnership law. But I actually have said already quite a lot about it. So the basic takeaway, if you're not from Portugal, Switzerland, or Germany, the basic takeaway is that there is no limitation of liability with a partnership like everywhere else. There is right now, by case law, the legal capacity for any kind of partnership without any differentiation, whether it is registered or unregistered. But there is still this kind of complicated concept of joint ownership, which will go away with the reform, that actually the registered partnership will be able to hold property and to have rights, which is important for DAOs. And what else? There is a so-called public partnership where actually you can have a fluid and unlimited membership. But of course, with the registration, if you want to be a registered partnership in the future, you will have to give the names and addresses of all partners. So it will become more difficult. Of course, we also, and you have mentioned it, it's the same thing. I don't want to be redundant here about the commercial partnership, the limited commercial partnership. I have it all on the slides. I think they're distributed. What I want to really focus on, because there has been a strong emphasis on the Swiss association. That is, again, more complicated in the German context. Surprise. So there is something called registered association, eingetragener Verein, and then there's an unregistered association. A registered association actually is more complicated than in the Swiss context because it is non-profit. So there is something called kind of an economic or a Wirtschaftsverein, economic, or let's say a for-profit association, but it has to go through a lengthy authorization process with the state and does not fall under the registration. And really the challenge right now for associations is to kind of, to find kind of the red line they might cross with their business activity and their non-profit purpose. When are they actually considered by the courts a for-profit enterprise? And that there is also a reform underway, but this is right now the problem. So we have, for example, the large automobile association of Germany, ADAC. They actually are a non-profit association, which is kind of surprising because they're everywhere and actually are more or less running a business. And actually you could say as long as it serves the non-profit status, it is okay. But they're also actually having an insurance, offering insurance to car drivers. And that actually has been an issue. And so they actually formed a stock company to actually wrap their insurance, which is kind of sounds familiar to the DAO world. So basically, if you put this into the DAO context, you would have a DAO that is an association, a non-profit association, and then again, you wrap a certain business activity into a sub-DAO. So it's not so unfamiliar. But the problem here really is to find this red line. And why do I mention the association? I think we all know that it's not an ideal world right now, and what could we do next? And I think we should kind of join forces with people who are actually trying to reform the corporate law independently of blockchain, right? I was in a conference in New York lately, and there was someone who is really a specialist in partnership law, and she said, where are you in the Uniform Law Commission? Why don't you come in, you crypto people? Why don't you try to change something? Why do you just talk in your silos and just talk among yourselves and complain that one element is missing? And there's actually a very interesting reform movement to actually get a European association going on the European level. And I think that would be actually a good idea to kind of join this movement because they are very active, and there also has been some movement in the European Parliament where they actually cite a European Court of Justice case where it said the freedom of association, and I come back to you, Madalena, the freedom of association is actually cannot be reduced to state intervention, right? We cannot just look at the regulation, but we also have to see how can we reform what we have here, the freedom and the possibilities in corporate law, and association actually could be a good idea. Why? Because it is it can be kind of peer-to-peer in a way that it is at least flexible in its governance. It can be membership managed, and also the executive board is quite flexible. For example, if you have a limited liability company in Germany or a stock company, the executive board has to be represented by natural persons, which of course might be a problem for DAO. So I think the association is an interesting legal form to look at in the future. Okay. Oh, okay. But let me just, running out of time too. But let me just have one word about cooperatives because they didn't really come up. I think that is also an interesting form to look at. And why that? Because it is also, Joshua talked about the spirit of DAOs, the community aspect, and I think one could talk about shared governance, but one should also talk about shared ownership. And I think the cooperative would be a nice model to look at too. And there's also on the European level, there's a European cooperative directive one could look at, and that would basically tackle the transnational challenge to actually look at a European form. And I run out of time, so I wrap it up here and also leave it up to the discussion. It's late. Sorry about that.
Thank you, Anja. And now it's the turn of, I hope to pronounce correctly, Sabine van Haecke Lepic. Please join me on the stage. Very, very briefly, because in an hour we have to leave. So please stay on the 20 minutes so we can open the discussion. Very, very briefly, Sabine teaches in many universities about Web3 and cryptocurrency. Is an expert for sustainable cooperation for the EU, and also she's in numerous research groups. His portfolio includes Industry 4.0, EdTech, RegTech, and alternative dispute resolution. I leave you the floor. Thank you, Sabine.
Thank you. I think today is a place to be to speak about innovation. And thank you very much to Florence Guillaume, because for all the work she does on for innovation and regulation too. Okay, so the subject is the search for appropriate regulation for DAO on the law. And yes, the term is decentralized autonomous organization, was the first used by Vitalik Buterin in 2013. And is a logical extension of smart contract. It's a smart contract of governance, you know, and it's a contract, long-term smart contract that contains the asset and encode the below and of an entire organization. So, in other words, it governs itself according to its own law and by a community of individuals pursuing a similar objective. So at a time of new web advance and the exponential growth of the crypto asset and blockchain market, new governance vehicles are being developed, including of which is the DAO. So the DAO, decentralized and autonomous organization, intend to support projects with the code as their only law. Code is law. Can state justice intervene in the event of a dispute? How can we interact with the DAO? Who is responsible? Your research is to find flexible legal framework bespoke to the particular characteristic need of DAO, while providing a degree of legal certainty. So we speak a lot about this. So I think I won't just say that French law does not currently specific regime. And from a legal point of view, de facto partner remain liable to third party and this unlimited liability. But you see, you are a lot of type of DAO, so it depends on the project. You can see traditional centralized system and DAO, yeah. And you have distinction between regulated DAO and Maverick DAO. Regulated DAO, it's incorporated under the law of state. Okay, so I don't want to be so long about that because we heard about that a lot of time today. But just I want to say that toward the search of new universal and international governance model, Koala model, that try to be a central concept of functional and regulatory equivalence, the model law defines the concept of DAO, establish rule of governance for DAO, and legal personality and limited liability, introduce of dispute resolution mechanism and tax treatment. But the limit of Koala, and Florence, Guillaume, and Seven Riva does a beautiful article about that. Limit of Koala is model attached to a state, and it depends of the state. So the risk is the risk of fragmentation if governed by several laws. And you are not, with Koala model at this time, no objective criterion of state affiliation. So the search for the true legal nature of DAO, the question on why attach DAO to an existing legal. And I was very happy to hear Madalena about out of the box, because I think definitely that innovation now, it's not innovation. We need to have innovation in legal. We need to have, yes, to be out of the box and to imagine a new way, because I think that Web3, it's a new opportunity, and it's a new mindset. And I think that we can have mass adoption if we are security. But I think you have a lot of regulation, so much regulation, and I think that the searcher in regulation must be address a new form of maybe tool, search a tool of regulation to be implemented in DAO to address a security. Because I think that if you have a lot of regulation, you have a lot of risk of fragmentation, and so you can be, you are not be able to you have a lot of risk, and DAO is international. It's international platform, association, corporate, and so. And my hypothesis is maybe, okay, we can search about company, we can search about cooperation contract, but I think the last one is about common. And I think it's very interesting to compare DAO to common to the research of Elinor Ostrom. So in France, we compare SAS to DAO, and we search the most corporate flexible, and yes, it's maybe SaaS, but I think it's not very interesting, because I think maybe we can study to contract. Maybe DAO is a contract cooperation. Maybe the philosophy of the DAO is to create a link between all users for a common purpose. So there are affectio societatis, which creates the link. It's not a link at the outset, but it could become one by qualifying this organization as a contract. So yes, in addition, it will give rise to rights that have a political function, but also an anthropological function in line with the principle of Web3. So yes, like a contract, DAO can have a consent. The participant do not necessarily have technical knowledge. The DAO will have in the white paper the necessary information, the price of the token, the process for reselling the token. This process will be facilitated by the increased transparency of this organization with the blockchain. And okay, for the contract, maybe the problem is the pseudonymity, but Claire Levener, who says about smart contracts, say that the impossibility of verifying a condition of validity is not in itself synonym with nullity, because okay, we can have it's not problem for anonymous for contract. So, but beyond concept, I think that DAO definitely is like common. So just I want to show this analyze comment, because you see principle one is a well-defined boundary. The community concern must be clearly identified as much the resource in question, and they are uncountable to the other. Principle two, consistency between the rule and the local context. Open participation, for internal monitoring mechanism, graduated sanction, conflict resolution mechanism. And yes, I want to explain that we speak a lot about, okay, enforcement, but I think that if on the Koala model insert a mechanism of dispute resolution on the system, and I think that we can have a conflict resolution mechanism integrate, and that is innovation, that is legal innovation. And yes, and definitely I think that the framework of common can be able to understand the framework from DAO. And you can see, and yes, it's a question of democracy. It's a new governance. We say that it's DAO, it's a new governance that will be totally disrupt the model. And I think that you can see exactly with this slide the disruption of the model with DAO. And you are different level of rule. So the operational choice level is the lowest. And when with the common, we have no need to have rule always. You need to have rule when there are a problem. So, and you need to have rule when, and that is innovation too. But beyond the concept, we need to establish a real proof of law. And I think even though we have a concept about such organization, corporate, contract, common, the main point for the certainty, for the liability, the proof of law. The proof of law for liability, the proof of law for responsibility. We need regulation tool on proof of law. And I work for the blockchain. It's a non-profit association, and the name is Logion. And Logion is a legal innovation. They take an original blind spot linked to blockchain technology, which is the legal reconciliation of the on-chain token with the proof of their existence ownership and value that are off-chain. It's the links between public notaries and public officer. And it's a link of rule of law because it's a legal profession. They validate the legal framework, economic and legal framework, before the entry to the blockchain. Because if you put in the blockchain a mistake, you are a mistake. And with the future, with the tokenization, the proof of law like this, with the link with a lawyer, with a legal officer, with a rule of law, with this link, we can address the new world, this new world, and they give some guarantee of sovereign protection, and this blockchain and intelligence artificielle infrastructure open the door to the law of strongest conflicts of interest and speculation, because we have finally the Logion project is addressing a fundamental philosophical question of modern law. Be careful not to sacrifice the fundamental of the rule of law, with principle of neutrality, impartiality, separation of power, to technologic solutionism. Beware of the temptation of the certain state to prefer either financialized or authoritarian governance of infrastructure to the democratic culture of preserving fundamental rights. With Logion, we belong to an international association with an economic model designed to ultimately finance the network. Token-based solution can now rely on a layer-based blockchain to manage the neutral and sovereign administration of the evidence. This is, I think, an innovation tool. This is essential for the defense of rights in digital democracy, essential too for the exercise of decentralized justice and for conflict resolution. So, to conclude, what is fundamental is to have a system of proof that respects the rule of law, and following the example of Professor Sénéchal, who argues that the case of common pool resource use, which relies to a large resource, must be taken into account. As DAO, as cross-border, they could potentially be interconnected, posing a fairly complex regulatory challenge. Elinor Ostrom, therefore, proposed polycentric governance to ensure good coordination between the various organizations, which may be at different level and location, while respecting the other principles set out above. So I think definitely that the organizational contract could be similar to an organization holding contract, which will make it possible to organize DAO contract according to the hierarchy proposed by Ostrom. It will have to provide for the establishment of rules that take account of this multi-level governance, so as not to fall into the tragedy of the common, which will lead to the loss of the DAO. So the avenue to explore, it's maybe a regulatory sandbox, a RegTech tool, and maybe a Reg Lab to implement a new way of innovation by exploring, because I think that we have so much regulation and we must now implement a new tool. Yeah.
Thank you so much. Thank you so much, Sabine, because you were absolutely in time. I cannot waste you and take time because we have the last speaker for this today panel and today day of the conference. So I'm going to present you, and this, okay, joining me, Professor Andrea later. Good last name, I suppose. Assistant professor at the Faculty of Law at the University of Amsterdam. Not only is assistant professor at the Amsterdam Center for International Law. Research focuses on technology-enabled governance, and it's embedded in the Sustainable Global Economic Law project. She researches global inequality and transnational lawmaking through private actors with focus on the digital economy and blockchain technology, but most of all, supported by a Veni grant from the Dutch Research Council. She conducts a research project on recoding values in the digital economy from 2024, but today you are presenting the project. Oh, absolutely, in the head. So avenues, in this case, in the head. And obtain, yes, the last thing I want to mention is also co-founder and director of research of the Sovereign Nature Initiative, working at the intersection of ecology, economy, and technology. She's a junior faculty member at the Institute for Global Law and Policy at Harvard Law School. But last thing, because I have to mention, many times we have mentioned here today koala, sorry, coal is another thing, koala model, and we have also a publication with Morshed Manan, who knows, all of you know that work with Primavera, about Logout, a glossary of technological resistance and decentralization. And I think it's useful because we need a lot of taxonomy after we have heard of you. And to me, it's the last word to say for today. We started with recognition and we finish with recoding. So a reason probably is, I leave you the floor.
Thank you very much. Okay. How do I click? Ah, here's the clicker.
Yeah.
Good. Okay, super. Okay, so I'm going to do my best to round up this beautiful day and bring some energy back into the room. Maybe, maybe not, we'll see. But I promise that I will stick to time, which I guess is the most important at this moment of the day. So first, I would like to thank you, Florence and Sven, for the invitation to be presenting here today. And I would like to just begin with a question. How do societies express what they value? And can DAOs bear an important key toward more equitable and sustainable societies? I'm following on here on the heels of the previous two speakers. We heard about the commons. So this is precisely the direction that I am taking here. In my talk, I want to invite you on a journey that locates DAOs as a social and economic phenomenon in a history of social rights and the decline of the social welfare state. What I will try to sketch out is that we are experiencing a crisis of values, both in the sense of increased inequalities, but also in the sense of ecological degradation to life-threatening levels. Whereas such questions were mainly negotiated through the lens of social rights mediated by nation states and then also human rights law on the international level throughout the 20th century, the state as guarantor for an equitable distribution and successful mediation for healthy and thriving societies has lost much of its trust. DAOs in my story stand out as the potentially new socialities in which values are being negotiated, or to put it differently, they can express socio-technical imaginaries of the future and give us an idea of where we might be moving toward. But to move step by step, think back to the early days of the pandemic. People showed their gratitude for care workers by applauding from their balconies. Everyone recognized the invaluable work of these essential laborers. However, despite this widespread appreciation, the care sector remains underfunded and care workers are poorly paid. How come? Similarly, there is a shared understanding that healthy forests play a vital role in combating the environmental crisis. Yet forests are being logged at a breathtaking speed. How come? Experts of various disciplines argue that one of the main issues lies in our narrow definition of value, which is limited to the price mechanism. In other words, we assess value based solely on what someone is willing to pay through supply and demand. The problem, these experts argue, is that the price mechanism does not reflect social and ecological values. To put it into more abstract terms, but also to show you that indeed the sense of a crisis of value is hitting across various disciplines, let me quote from Mark Carney, former governor of the Bank of England and the UN Special Envoy for Sustainable Finance. He says, "The embrace of markets and their subjective valuations has led to a society that has been robbed of its capacity to express what is important to us. We are witnessing a disjuncture of values, where the primacy of economic or financialized value leaves little space for social and ecological values." In law and legal academia, this crisis is expressed in the often harsh critiques of social and environmental rights as being toothless and having had not nearly enough significant impact in the world. Of course, the history of social rights differs significantly from the history of environmental law, but the sense that neither field is strong enough to change the current destructive course has been expressed by climate and social justice activists and fills libraries with academic texts. Whereas the state served as the most important field of projection for safeguarding rights, it is now often understood to be in the way of social progress. What I'm suggesting is that we are seeing a fundamental shift. What the activism is expressing is not simply a side phenomenon driven by a fringe of society or some, as you say in German, Weltverbesserers, where for a long time the idea that wealth would trickle down held a credible promise towards social mobility. We are now seeing that the normative and social consequences of rising inequality are trickling up and are reshaping all dimensions of normal politics, as the historian of social rights Nehal Butta says. This trickling up is best expressed in the big push towards so-called ESG investment. ESG standing for environmental, social, and governance facilitating investment. It is telling that this push comes out of the financial industry, with someone like BlackRock's Larry Fink being one of the most well-known proponents. So what to make of the fact that through a certain lens, social and environmental activists seem to be closer to financial institutions than to publicly elected governments? Of course, this is a provocation that calls for many caveats and differentiations, but I would still like to point to the fact that financial institutions seem to have understood that the rampaging inequality and the disastrous environmental phenomena of wildfires and floods are posing a real risk to the stability of the financial system and have kicked into action. The point I'm advancing is that we are witnessing a paradigm shift where the direction of the future is unclear. So now, entering DAOs. I locate DAOs at the center of this debate because they seem to be harbingers, or to put it more eloquently, socio-technical imaginaries. Scientist Sheila Jasanoff describes socio-technical imaginaries as visions of scientific and technological progress that carry with them implicit ideas about public purpose, collective futures, and the common good. Artist and writer Ria Myers put it well when saying that DAOs and the blockchain in general are indexes of our contemporary economic imaginary. In contrast to entrenched economic systems, they are novel and public, so we can see them and reflect on their functioning and effects. Importantly, she points out, the making explicit of value and values, structured both in terms of financial behavioral incentives and the language and meaning making of their participants, is what gives DAOs such epistemological, ontological, and aesthetic potential. As we have seen and heard today, DAOs come in as many shapes and ambitions as you can think of. They have been called the future of the firm, an innovative form of a startup, a new way of doing not-for-profit work, a new form of commons, an artistic experiment, or even the base layer for new state forms. What is particular in DAOs is that they combine a number of elements that not only express the zeitgeist, but set them apart as powerful tools for experimentation. They are digital financialized infrastructures operating through new technologies. But more importantly, they enable collectives to govern large amounts of money or tokens without the need of a bank account or a corporate form. Now, everyone in this room knows that at some point the rubber will hit the road and DAOs have to appear before the law. But a lot of experimentation has been enabled through the fact that DAOs can be self-authorizing when it comes to the constitution, measurement, and distribution of value through token economics. As such, they enact socio-technical imaginaries in a very powerful way. And as with any technological novelty, the technology itself comes embedded within an intellectual history and cultural milieu. Just as the question of social rights is one that can only be understood contextualized with reference to time and place to understand the social formation advanced in their name, different kinds of DAOs grow out of different kinds of intellectual and cultural traditions. This overview of books is a short attempt at showing that the spectrum is very broad, ranging from radical markets to radical friends. Whereas the proposition of Eric Posner and Glenn Weil sees the expansion of the market toward a true open competition as the key to societal renewal, Balaji Srinivasan proposes communities by choice to connect into so-called network states. On the other end of the spectrum, in the book Radical Friends, edited by Ruth Catlow and Penny Rafferty, we find a selection of DAO examples trying to move toward post-capitalist alter economies. Writer and philosopher Eric Bordelot points out that one of the key characteristics of DAOs is that they move the economy into a design question. As he puts it, blockchains are governance-making machines. The protocol is the institution. As such, distributed ledger technologies allow for the formation of all sorts of digital membranes, economic enclosures, or digital commons yet to be invented. Thus, with crypto economics, the economy becomes a design question. So this is the space of innovation and experimentation with small-scale token economies by design. We have yet to see how this plays out, but what is certain is that the relationship between DAOs and the established jurisdictional frameworks will be extremely important. As mentioned before, eventually the rubber will hit the road and the questions of accountability and redress will become crucial. Let me conclude by saying that my impression from working for many years in the blockchain space, and more specifically in the blockchain space interested in public goods, commoning, and more sustainable economic designs, shows me that the regulatory uncertainty will hit these projects hard should they manage to become sufficiently successful. The lack of funding in such projects makes legal advice difficult and costly to obtain, and founders and activists are then left with the legal risks of running DAOs without a protective shield of limited liability. But this is not the only issue regarding the relationship of DAOs and law. To build a counterpoint to the wildly held idea that so-called legacy institutions like the state are only constraining, I would like to end on a plea about being careful what you wish for. States have been the sociality upon which the quest for social rights was projected, and it is through public constitutionalism that the playing field was leveled. Think of labor laws, women's rights to vote, environmental law, or the civil rights movement. The state has been by far the most successful sociality to carry these claims at scale. Social ordering outside of the framework of the state is a question of private ordering and older than the concept of the state itself. Think of churches, religious communities, whatever you can think of how humans associate. However, some of the most powerful forms of private ordering have always been related to economic activity, from lex mercatoria to commercial and international investment arbitration, and so on. Historian Quinn Slobodian, in his latest book, Crack Up Capitalism, speaks about zones that are still part of a sovereign state but have a special status, usually special economic zones. The history of international law is full of such examples, from capitulation treaties for extraterritorial jurisdiction in the Ottoman Empire in the 16th and 17th century, to consular jurisdiction in Shanghai and other places in the 19th century, to the contemporary charter cities, such as Prospera in Honduras. As these zones are usually mainly concerned with economic activity and the possibility for accumulating capital and wealth as unencumbered as possible, the proposition of breaking away from legacy institutions and the conventional legal system is not straightforward when it comes to delivering social justice. So, social rights have rarely been granted by design. Or to go all in with a quote of James Baldwin, freedom is never given, it's always taken. Letting go of established law also means letting go of social rights, which also means running the risk of losing the history of struggles for social justice fought for with blood and tears. Let me land on the note that a conference like today matters a lot, because the relationship between DAOs and law will profoundly shape the forms of DAOs and how these DAOs can recode value in the future. So I really want to thank the organizers for bringing us together and making this possible, because we are shaping the future.
Thank you, Andrea, because it was not so late before. You do not use all the time that you have. So the discussion is open, and please join me on the stage, all the speakers of this panel, and I leave the mic to Professor Guillaume. Perhaps you want to say something.
So I open the discussion on European Union DAOs. Who has a question? Come on, they are all here for you.
So I have a first question for, I think it's for the group, the first group with Biyan, with Madalena and António. So the three of you, you talked about, the DAO that is decentralized enough, either to not fall under MiCA, or Biyan, you were really saying that if you have an entity that is not decentralized, if you're not willing to, give away the power, you shouldn't be a DAO. So in the end, can you give us your intake, and then the others also, if you want to join in the discussion? What is for you, what kind of entities should be DAOs? What is the purpose of a truly decentralized entity? And why do we see so many centralized entities on the blockchain in the Web3 space?
Yes, right? No. I will take this one. Perfect. Yeah, that's a pretty good question. I think it comes down to how do you define a DAO, right? And that's the biggest problem that we all face, because it became so broad over the last years. Like when I first started looking at DAOs, it was still kind of the idea from the DAO, this investment DAO kind of style, and then everything became a DAO. So I think the idea of DAO should be saved for this truly decentralized on-chain governance, and everything out of that, which needs some centralized part and centralized entities, should stay centralized and should get another name than a DAO, because I think, as I explained in my talk, this calling it the DAO puts a lot of pressure on the team, on everything, to appear decentralized if they are not. So I think all the businesses who need a centralized point, who don't want to give out the power, I think for them it would make more sense to maybe use a DAO as the on-chain governance protocol, which kind of leads to where the business can go, or which kind of involves the community. But I think they shouldn't try to force this structure that they have in some legal entity, which then can become a license, if it's in DeFi, can become subject to a license regime, or can create more problems than it really helps. That's kind of the idea behind it.
Thanks. So thank you, Sven, for that question. I think there's a contradiction in terms when we speak about decentralization and having an organization, a vehicle that promotes cooperation between its members. So we have seen that sufficient decentralization or full decentralization implies that you should have, to avoid legal risks, you should have many legal entities. It could be corporate entities, and each one of those entities should be responsible for a specific area of that DAO. Like one, we should have an entity for business development, another one for protocol development, and so on. But when you think about that, it's almost impossible to have to pursue a common purpose if these separate entities do not communicate with each other, and if they do not, to a certain degree, cooperate with each other. Because if I'm dealing with business development, I really need to know which business am I developing. So this idea that is possible in theory to fully decentralize operations, being it with corporate entities, with sub-DAOs, or any other arrangement, it has this problem regarding cooperation. That is why I don't know to which point we can say that DAOs are truly a contradiction in terms, like decentralized and at the same time organizations. So I really liked the proposed approach this morning about, I don't know the exact name, decentralized governance frameworks. They're probably a more accurate way to describe these arrangements.
Yes, so I agree, and there's this distinction between decentralized organizations and decentralized autonomous organizations. I think we should probably take the letters apart and try to answer each question separately first. And yesterday night we discussed about what organization means, and is it organizing or organization? So when do I step from a contractual arrangement to an organization? And for example, if I take liability, I didn't get to it. So before we jump to the conclusion and get into this limited liability company box, we could think about a contractual regime to set up an insurance or to have an indemnification regime, and basically, yeah, create a protocol where we put this in escrow and then have a when-if situation, which would be a contractual arrangement. And then in terms of organization, that we think, yeah, Andrea, you probably will talk about the network state, that we have, in the first place, we do not lose sight of the ideal of decentralization, that it actually, independently of autonomy, decentralization is a question, as you very nicely elaborated, we have to ask ourselves. And Joshua has talked about the spirit, the community, the culture. So, for example, I kind of rushed through, but the cooperative, right? The question of whether you want to just share governance or whether you want to share ownership, and how does this ownership look like? And as you said, think out of the box, kind of let's not, because that's the most developed in the financial space, DeFi, that we lock ourselves into this LLC box, but kind of think beyond that. Yeah.
I mean, just one mini note, I would say, I think one of the things that maybe has not come up so much during the day, but I think that on practical terms is so important about DAOs, and then if it's a DAO or if it's something else, is that you can make decisions about funds together. I mean, that's a big deal. If you really want to get something done and you want to work with other people and you want to make decisions about money in big terms, to a degree, that's a very pragmatic reason. And so then what does that mean and how do you do that? And if it's called a DAO or not, is one question, but I think that the possibility of doing that has been really significant for all of the innovation that has happened. And so I think, yeah, that's one of the key features that has come forward with DAOs that is so good for people being able to organize like this. And also just on a second mini note on the inequality question also of making finance more attainable for smaller scale organizations. So you don't have to have all the money to do the legal, to get the bank, to do the whatever it is. You can just do that on a smaller scale. So I think this is an important part.
Just to add, very, very briefly, why not decentralized independent organization? So it depends how you conceive autonomy. I think it's just a way to understand the relationship between powers and society, market. I appreciate all the speeches today. And we see that this kind of autonomy perhaps comes from the experience of the Anglo-Saxon countries, where autonomy is conceived as the maximum freedom. Because independence, you have the system at the top. So it's just a provocation because we have you brave that you remain until this hour. So I want to provocate you. And we have next question. Thank you.
So maybe this is also a provocation.
Sorry,
so.
Your mic doesn't work.
No? Hello? Yes?
It's back
Yes.
here.
Okay. So I was saying that this is perhaps also a provocation. So back on to the meaning of decentralized autonomous organizations, I asked myself of, again, what is the limit of decentralization if they are actually autonomous and if an organization is limited to financial interactions? My question is primarily directed to Biyan, because you were especially convinced that it should be an aspiration of organizations that claim themselves to be DAOs, that they should maximize their decentralization. But is it even a reasonable aspiration? Because we may be looking at some elements that are being decentralized, but how about the communication channels? You were saying, yeah, the development should be decentralized, but where? In multiple code repositories, in multiple Discord channels, and practically this poses a limitation on cooperation and coordination. So aren't we always going to fall back to aspects of centralization that oftentimes are decidable? And how would you see the limitations of decentralization?
Yeah, I think that's a fair enough, a very good question. I think it boils down to, first, if you want to be decentralized, right, and not just use it. But second, I think, and we heard that a lot, I don't think if you coordinate yourself, you centralize in any way. I think you can also coordinate yourself in a decentralized way as long as you do it public. Because I think the key factor, and if you look at securities regulation in the US, but also if you look at the NCAs in Europe, they always boil it down to the point that there's a centralized entity who kind of has this information asymmetry, this advantage over the others. So if you discuss in an open channel, which is open for everyone, you have some protection for bots, but let's say Discord, Common Ground is new now, building a Discord for Web3. If you have these kind of structures, you can just like the initial team can publicize an idea and roadmap there and just let everybody work on it and just coordinate together. I think it doesn't need to be that out of decentralization and 5 different sub-DAOs, one idea comes out. It's still all right if there's somebody who initiates it, but I think the key is there that the initiating team or the person does not have the control to push it through. So there will always be, and that's in every organization, there will always be people who kind of push it more, but I think the key is that this comes also out of the community that you build. So the first thing, of course, before you launch a DAO, you should have a community. Before you launch your network, you should build up people who want to contribute to it, or as you said, it won't be possible. And the key there is to really be transparent, even with things which I think it's also the key for DAOs who manage that, because in some things it's very difficult. You have like NDAs or clauses like that to dispose things, but I think it's the key, if you manage this kind of decentralized structure, that you also put a lot into the code, put a lot into on-chain transactions, do, as I said, on-chain agreements. Everything should be transparent, and if you do that, I think there's no issue if you have from a certain initiator bringing something which will then be broadly discussed and then actually enforced or implemented, if that answers it.
But if you were just... No, but thank you for this question too. If I imagine you mentioned communication protocols. So what do we have in Web 2? We have these different platforms, right? And we have this fragmentation of me being Instagram, me being LinkedIn, me being, I don't know, WhatsApp. And then we have the meta level where Zuckerberg, for example, suggests to be kind of the railroad between these different platforms. And I imagine that decentralization is not an abstract principle which has to exist. I agree, but I would kind of throw in the sovereignty, which also was an aspect that was mentioned today, that it is not in the future the Zuckerbergs of this world kind of providing this railway between these different platforms, but and upholding basically this fragmentation, but that in whatever network I choose as a sovereign self, participate. I don't know whether that is kind of an answer, but I think it's a valuable comment that we should not just, or if I understand you correctly, have decentralization as such and then create even more fragmentation, but think of how we deal with it. Yeah.
So I agree with you in the sense that, well, I don't know if that's your opinion, of course, in the sense that I think that full decentralization, at least in terms of philosophy, it's aspirational. So when we look at political decentralization, we should consider, for example, influential mechanisms, the way people vote. And we all, as a community, we struggled with this idea since Aristotle. So we know that the democracy idea, the democracy paradigm relies on the idea that diversity brings better solutions. But we also know that some people, or most people, really don't know what they are voting about. So regarding influential mechanisms, we always have this tendency to have some groups of people that follow other groups of people. Because, well, in social terms, they are influential, they have this specific position in a community that makes them influential. You don't need to have actual binding mechanisms to have enhanced voting rights, but these influential mechanisms, I believe they are always present. Of course, we can argue or you can discuss if they are relevant when assessing decentralization in legal terms. Probably they shouldn't be. But still, at least in philosophical, as a philosophical idea, full decentralization is probably just a mirage.
And also just to add to Madalena what just said, well, also two conceptual notes about decentralization and autonomy. Well, the first more conceptual, almost linguistic note is that, well, adjectives are comparisons at the end of the day. So something is only decentralized because something else is centralized, or something is autonomous because something else is dependent, or something is big because something else is small. So basically, that brings me to my second point, which I think fits with Madalena's point very neatly, which is full decentralization conceptually. Well, I don't see it as like a binary thing. Either it's fully decentralized or it's not. It's more of a spectrum of decentralization in a way. And of course, the job of the law, the task of the law in that way is to, be it written law or legal scholars or courts, is to basically define the indices or the clues to determine that decentralization, as also as Madalena has implied as well. But of course, it will never be, or it's very difficult to be like a very strict and a very clear line. There will always be doubtful situations, but otherwise law wouldn't be fun without that if it would be all strict. So yeah, I also agree that full absolute decentralization is, once again, it's nice to think about it and to strive towards it, but in the end, it probably doesn't exist.
Just a short comment, like, I don't want to say that I have the idea how to be fully decentralized. My idea was, how can you advise a client to be decentralized enough to not fall under MiCA or to not be a security under US law? Of course, I don't claim to have a solution to the philosophical question, but I was more from the practical perspective, how can you kind of structure your project that you don't fall under these regulations and can still operate more or less safely?
Yes, I think that decentralization is not a mirage if we does a bridge with rule of law. Is we address a new form of democracy, because maybe with a decentralized by graph, I don't know in English if we say by graph, and not to fight the system now, the Zuckerberg system, but to maybe to be able to rendre obsolete the platform, private platform, to insert a rule of democracy in decentralized. And I think for the Data Governance Act, for the data, we need to have blockchain on decentralized, on crypto secret. Yeah. So I think that, yes, I think definitely it's not a mirage if we does a link with the innovative democracy. Yeah.
Okay, so we have one question, two questions. Okay, so those will be the last questions of the day. Yes, Ayla.
I think this is one for Andrea and Anja. So I really enjoyed your speech, Andrea. Personally, very much agree about the potential of DAOs to create a design space for society. And given that the EU has, at least in recent history, been a sort of a leader for what maybe the world and public policy should look like, do you see sort of a public policy imperative for the EU to be funding or particularly active in this space and actively influencing who and how the future of our society is being shaped and how those experiments are happening? I mean, just as one concrete example of what I'm getting at, when you look at the current blockchain space and who the builders are, there's, you know, a very large percentage being white or male coders. And without wanting to make this a gender topic solely, I think it's in this sort of area where we think DAOs are the future or the design space of future society. I'm curious to hear your thoughts on how the EU should be behaving around DAOs.
Should I? Yeah. Yeah. Thank you very much for the question, and thank you for the kind words. Much appreciated. Is it? Yeah, that works, right? So I think that the question has a number of layers in a sense. So I think that the question of how the EU policy should look like, in a sense, takes the current situation and says, okay, so we have this moment in which we are, and what can some big regulator like the EU do? And I do think in that sense it's a big responsibility, and I think it should be picked up specifically on what you mentioned now in the last sentence of where is the funding going to, what communities are being funded, with what kinds of ideas, how easy is access to experiment around that. And I do think that, again, I think that the sense that there is a real crisis, both environmentally as well as socially, I think that is felt and understood. And I think one of the ways in which to respond from a regulatory perspective is to create these sandboxes so that you can have self-determined modes of experimenting, because I think that's where the life is and that's where the good stuff is. So I think you just need to enable people to do that. And I do think that you have to have a very good eye on diversity on this, because otherwise we end up with the same gender and other diversity inequalities as we are seeing right now. And I mean, I think that this is also, I think that just from the question of decentralization and automation, so I do think that decentralization as understood to enable self-determination on a lot of different levels. I mean, you can also call it the anarchist idea, but that probably many people don't like that so much. But I think it's really meant that you support collectives that do things, and they do them well, and they do them the way they want to do them, and to enable that. So for me, that is the decentralization in the DAOs. I think that the automation stands in quite a tension with that goal of the decentralization in that sense. So I think that the automation is a very transactional proposition, and has to be by definition, because it's if-when conditions, and you have to have that. And I think it's important and good to have, but I think that it stands a bit in tension with the living life that happens when you don't have this formalized thing. But yeah, I'm fully on EU. Please, sandboxes for great projects. Make it easy. Female founders first. Let's go.
Okay, and I would add like a concrete example where I actually think, or let's say, as an introduction, we have discussed today the US and said that the US regulatory agencies are less in a cooperative mode than before. You know, it used to be that you could come in, you get a non-action letter, and then they basically formed a rule out of it, and then you had a rule. And this is now we have regulation by enforcement. You cannot talk to them. The EU, let's say, is a little better. You have, let's say, on the regulatory side, I think the cooperative, or like say the communication works quite well in making the rules. Everyone is actually invited to comment when they actually now establish new technical and operational standards. And like in the US, you always have these conferences where you turn to the audience and say, well, you do something, you call your senator, you call your representative. I think for the advocacy groups, I think it is important, like European Crypto Initiative or so. It's incredible what they're doing, that they are in all these communication processes to give feedback. And I think this is very important right now. But as a positive example, you have the European Community DJ Growth in digitalization of industries. They have put out a meta policy, a Web 4.0 policy, and I think they invited stakeholders from across different communities to actually talk about what is important. And I think going back to my last point with the data sovereignty, I think that is important, that we are aware of our own power, or that we are kind of aware of our, what we can do. And then a final note concerning data, I think, and advocacy right now. So with the Data Governance Act, you have new intermediarization. You will have a data trustee, and it is not at all clear what kind of legal form that will take. I can already say that the German Ministry of Research, Bundesforschungsministerium, actually has financed a grant, Professor Möslein and Omlaw, to find out what kind of legal form this trustee could have. And this, again, back to us academics, I think we have a huge responsibility to be active and, as you say, think out of the box what we could do there. Thank you.
Thank you. Do you have a short question, because we're running totally out of time? Or you can keep it for tomorrow? You can? Can you live with this? Okay, thank you very much. I'm sorry. I'm really sorry. So, mesdames et messieurs, as we draw the curtain on day one of our conference, I'd like to say that it has been a very rich and enriching day. Our moderators and speakers have not only painted a panorama of the diverse legal treatments of DAOs across jurisdictions, but also highlighted their great potential and the challenges that lie ahead. The multiplicity of perspectives underscores the dynamism and complexity of the DAO ecosystem. We would like to thank all the participants and also the audience for their highly inspiring contributions. Thank you very much.